this is Preet Verma and this is video of the legal aid under the Indian legal system. The adversarial system is characterized by the technical nature of law and being called as formal because it requires pleadings and court fees. Added complexities like bribery and poverty among the Indian masses makes access to justice highly problematic. In the words of B. Sivaramya, the observation of Anatole France that the majesty of law treats a millionaire and a pauper sleeping under the bridge alike held good in the case of dispensation of justice by the courts modelled on adversary system. The Supreme Court in the M.H. Hoskot versus State of Maharashtra observed that our judicature molded by Anglo-American models and our judicial process engineered by kindred legal technology compel the collaboration of lawyer power or steering the wheels of equal justice under the law. Now, free legal aid in post-independence India. A meeting of law ministers of various states held in 1958, and as a result of this, the Kerala Legal Aid Rules in 1957 created, which extended the protection of legal aid to those persons who were unable to afford access to courts. The Law Commission of India in 1958, in its 14th report, devoted a whole chapter to legal aid. In 1976, 42nd Amendment Act passed, and as a result of this, Article 39A was added in Part 4th of the Indian Constitution to provide free legal aid to poor people. In 1987, the Legal Services Authorities Act, that is LSAA, passed, and the Act expanded legal aid beyond merely the poverty-based notion to the disadvantaged groups. Besides the establishment of Lok Adalats and permanent Lok Adalats, strengthened the free legal aid services. Now, free legal aid under the Indian Constitution. The 1976 Amendment of the Constitution inserted Article 39A in the Constitution, which is as follows: equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The wording of Article 39A reiterates that kind of an equality which shall promote access to justice for all by creating equal opportunity. Menka Gandhi versus Union of India, AIR 1978, SC 597 provided clarity on what procedure means under Article 21 as the right to life or liberty could be violated only by a fair, just and reasonable procedure. In the adversarial system, the fairness requires legal representation. Creation of equal opportunity for accessing the courts is a dimension of the equality clause in Article 14. Now, free legal aid by the state. The 14th report of the Law Commission of India mooted the idea of providing free legal aid to the poor by the state. The report highlighted the responsibility of the legal community to administer legal aid scheme and the state to fund legal representation to the accused in criminal proceedings, appeals and jails. In 1950, the Union government initiated the National Legal Aid Scheme, which faced financial shortages and died a natural death. In 1973, in the second phase, the Union government constituted a committee under the chairmanship of Justice Krishna Iyer to develop a legal aid scheme for states. The committee devised a strategy in a decentralized mode with legal aid committees in every district, state, and the center. A committee on judicature was set up under the chairmanship of Justice P.N. Bhagwati to implement the legal aid scheme. This committee suggested legal aid camps and nyayalayas in rural areas and recommended the inclusion of free legal aid provision in the constitution. In 1980, the Committee on National Implementation of Legal Aid was constituted with Justice Bhagwati was its head. Subsequently, the Parliament enacted the Legal Services Authorities Act 1987. Now about free legal aid under criminal law. So Section 340 Clause 1 of the Code of Criminal Procedure 1898 provided that if a man was charged with an offence punishable with death, the court could provide him with a counsel upon his request. This was subjected to a twisted interpretation by the Supreme Court by classifying it as a privilege rather than the duty of the magistrate in Tara Singh versus State 1951 AIR 1441. However, India in the Code of Criminal Procedure 1973 facilitated statutory implementation of free legal aid subsequently. Section 304 Clause 1 provides that in a trial before the sessions judge, if the accused has not sufficient means to engage a pleader, the court should assign a pleader for his defense at the expense of the state. Now, Free Legal Aid and NALSA Regulations 2010. In 2010, the National Legal Services Authority, that is NALSA, NALSA of India adopted the National Legal Services Authority Free and Competent Legal Services Regulations in exercise of its powers under Section 29 of the Legal Services Authorities Act 1987. The regulations are applicable to the legal service committees of the Supreme Court, High Courts, the states, districts, and taluks. Some broad features of the regulation relevant in the context of the paper are: first, selection of panel of lawyers. The panel shall be prepared by the executive chairman of the legal service institution in constitution with the Attorney General for Supreme Court, Advocate General for High Courts, Government Pleader for districts or taluks, and the Bar Association President. The legal practitioner shall have 3 years or more of experience at the bar for being considered for impanelment. The personal traits like competence, integrity, suitability, and experience shall be given due consideration. Separate panels shall be maintained for different types of cases. The regulation also provides for retainer lawyers. The panel was to be reconstituted every 3 years without disturbing the work of panel lawyers already representing ongoing cases. In such cases where the panel lawyer wishes to withdraw from a case entrusted to him, shall communicate this to the member secretary and the latter may permit him to do so. The panel lawyer is barred from taking any fee, remuneration, or other valuable consideration from any person for whom legal services are rendered under the regulation or act. The panel lawyer may be withdrawn from a case or his name removed from the panel on account of non-performance of duties satisfactorily or for actions against the object and purpose of the act or regulations. Next is payment of fee. The regulations specify the rules regarding the payment of fees for panel lawyers, which shall be in accordance with the state regulations without any delay on receipt of completion of proceedings for them. It suggests periodic revision of honorarium for the different types of services provided by panel lawyers in legal aid cases. Next is senior advocates. The services of senior advocates may be availed if the chairman of the legal services institution forms an opinion to that effect in cases of great public importance and where serious threats to life and liberty of the applicant exists. Now, the criteria for giving free legal services. In fact, it is another debatable issue that who will get the free legal services, either every person or only certain class of people. However, till now some criteria are decided to provide free legal service. Every person who has to file or defend a case shall be entitled to legal services under this act if that person is a member of a scheduled caste or scheduled tribe, a victim of trafficking in human beings, or beggar as referred in Article 23 of the Constitution, a woman or a child, a person with disability as defined in Clause I of Section 2 of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1955, 1 of 1996. A person under circumstances of undeserved want, such as being a victim of a mass disaster, ethnic violence, caste atrocity, flood drought, earthquake or industrial disaster, or an industrial workman, or in custody including in a protective home within the meaning of Clause G of Section 2 of the Immoral Traffic Prevention Act 1956, or in a juvenile home within the meaning of Clause J of Section 2 of the Juvenile Justice Act 1986, or in a psychiatric hospital or psychiatric nursing home within the meaning of Clause G of Section 2 of the Mental Health Act 1987. The Act renders a helping hand to all those categories of citizens mentioned in the above. Now, the larger question arises whether an economically sound person who falls into these categories, should he or she be allowed to seek free legal aid? If they are allowed to seek free legal assistance, then such an approach and its ramifications on the system should be carefully analyzed. Thus, the undisputable question arises whether the wealthy and affluent in the society needs to be provided legal aid. The economically who falls into these categories, whose income runs into crores of rupees, make use of the free legal aid. Thus, in a way, they are hijacking the real sufferers for whom this enactment was made. Now, types of legal services under free legal aid. So, the free legal aid are provided before commencement of the litigation, that is pre-litigation legal services, during the litigation and post-litigation. So, first is pre-litigation legal services. It is rightly said that prevention is better than cure. In these days, the number of litigations is increasing day by day, which is against smooth administration of justice. So far, emphasis was given only on post-litigation assistance or help, but now it is being realized that pre-litigation legal services are more useful than post-litigation legal services. So the pre-litigation legal services includes legal education, legal advice, legal awareness, pre-litigation settlement, etc. So guys, that is all for today. See you in the next video. Bye bye.